Here at Gunderson, Denton&Peterson, we do a lot of work relating to contracts. We help draft contracts, we advise clients about the effect of contracts, and we get involved if a contract's been breached and there needs to be litigation. It's important to understand the different law that applies to different types of contracts. There's something called the Uniform Commercial Code, and it applies to certain types of contracts that usually have something to do with what a merchant would be involved in. So for example, anything relating to the sale of goods, or leasing goods, or securities typically is going to be covered by the Uniform Commercial Code, or the UCC. The common law of contracts, that is the law of contracts that's been around for years and years, applies to pretty much everything else. That would be services, employment, real estate transfers, and other kinds of things. It's important to understand that there's a few differences between the UCC and between the common law of contracts. For example, there's the principle of acceptance. Under the common law, a contract is only formed when someone gives an offer and the other person accepts that exact offer. But under the UCC, if a person gives an offer and then the person on the other side accepts the material terms of the offer, then there can still be a contract formed. So for example, if a small little thing is changed in the acceptance of a merchant's contract, then under the UCC that contract might still be valid. Of course, if you're going to be fighting over whether the contract is valid or not, you need to understand whether the UCC applies or whether the common law of contracts applies. The UCC also has specific rules relating to the doctrine of impracticability, which doesn't even sound like a real word, but it can be important under the law. If a contract is impracticable, meaning it's really hard to do, then it can be voidable under the UCC. The idea of the UCC was that merchants would be able to do these economic transactions, and what would be commercially sensible would be what the UCC would allow. And so if one side ends up having to spend a lot more money to perform a contract than the parties had anticipated in advance, then they say, well, that's impracticable, and therefore it could be voidable. The statute of limitations can also be different for UCC claims versus contract claims. In Arizona, typically, a written contract is going to have a 6-year statute of limitations. Typically, an unwritten contract is going to have a 3-year statute of limitations. But under the UCC, you usually have a 4-year statute of limitations. There are exceptions to those rules, but obviously you need to know which area of law applies so that you know when your statute of limitations runs. There are other differences between the UCC and the common law of contracts as well. So if you've got an issue relating to a contract, it's important to sit down with an attorney who understands the difference between a contract that's governed by the UCC and one that's governed by the common law of contracts.